The law is complex, but it doesn't have to be a mystery. We are talking legal literacy, not advice. So don't worry, not getting an invoice. I'm Simon Jenga, and welcome to Simon Said. Today we are talking about what powers an attorney has under an enduring power of attorney. The phrase attorney is used in a number of different contexts, both legally and non-legally. Today, all we're talking about is an attorney that has been appointed under an enduring power of attorney for property or for personal care pursuant to the Protection of Personal and Property Care Act 1988, or the Triple PRA. So that's the only type of attorney that we're talking about as part of this conversation, and we're really deep diving into what are their powers and what are the restrictions on those powers. So, as a baseline, the document that is signed, as in the enduring power of attorney document for property or personal care, lays out the restrictions and the requirements on the attorney and how they must behave, how they must act. So it points out whether they are acting jointly with other people for property, whether there is a successor attorney appointed that would take over if they are unable to act, whether they have to provide information to anyone, whether they have to consult with anyone. Two big obligations that can be placed on an attorney are the requirement to consult and the requirement to provide information. Consulting is a positive obligation. The attorney can only make decisions if they have actively sought out specific people identified in the document and consulted with them prior to making a decision. The degree of consulting is grey, but effectively they have to have been given an opportunity to weigh in on the decision. At the end of the day, the attorney is the one making the call. So the attorney is not required to adjust their decision based on the substance of the consultation with those specific people, but they are required to consult in good faith. If those people are unavailable, so say they try to phone the person that's identified that they need to consult with, but they don't pick up, and the subject person is in the hospital, needs surgery, decisions need to be made, the attorney has breadth to do what is reasonable, so that it's reasonable consultation. If they need to make decisions because someone's on the table and they can't get hold of someone, they need to make decisions. And that's critical. That's critical to understand in terms of the attorney's obligations, that it is a duty on them. Ultimately, they have to act reasonably, overarching. The provision for information, on the other hand, is not a positive obligation, it's a latent obligation. And what I mean by that is that the attorney is not required to actively provide information to the named people. It's up to those named people to seek out information from the attorney, at which point the attorney cannot withhold the information. So the obligation is on the attorney to release that information as soon as the request comes in or within a reasonable time frame, but they don't have to prepare annual statements or anything like that to keep everyone up to date on the basis of just needing to provide information. So those are the two big obligations that can be placed on the attorney, and within the documents there's also space for a number of other restrictions. So it could be that the attorney is allowed to give gifts on behalf of the donor, but they can't give a gift over $500, or they can only give gifts to this class of people. Those kinds of restrictions are allowable but less common. And generally what we see is people trusting the attorney to make judgment calls, and we also put in an overarching restriction that the property of the subject person or the property of the donor can only be used to benefit that person. So as a kind of baseline, it's very rare for people to want to allow gifts on their behalf to continue based on an attorney's judgment. Generally speaking, people are quite comfortable for gifts to cease and for property to be used primarily for their benefit once they've lost capacity. And then it's then when they pass away that the distributions will occur under their will. And that's where gifting can then be reignited amongst the family after passing, rather than during that process of incapacity. One of the things that I personally like about that approach as a starting point is that when someone loses capacity, the focus is on them. Focus is on looking after them, keeping them comfortable, and also having an environment where the family are engaging with them in whatever capacity everyone is wanting, willing, or able to engage. So that focus then becomes on the subject person, on the donor under the enduring power of attorney, rather than about then, okay, so now that we can carry on gifts, Dad always gave us this for Christmas, so I'm going to use my judgment to determine what is now done in terms of gifts. Certainly possible, certainly not unethical. It's just not common for it to be the focus for the donor or for the family at that time. So everything I've just described kind of covers broadly when someone's already lost capacity. Now, if someone has capacity still and they've got these enduring powers of attorney in place, if the property document allows for that attorney to make decisions whilst the person has capacity, then the attorney has an obligation to consult with the donor before making decisions. As soon as the donor loses mental capacity, as adjudicated and judged by a health professional, then that obligation evaporates. For obvious reasons, it doesn't make sense to consult with someone that has medically lost capacity. The obligation to consult only persists as long as the donor has mental capacity. And then, as an aside, in terms of personal care and welfare, the attorney doesn't gain the power to make decisions until a loss of capacity. And the policy reason for that is very simple. It's that someone should retain the ability to make decisions for themselves as long as they can in relation to their own body. So the law is geared around preserving that for as long as possible. When someone then loses capacity to make those decisions, including to understand the consequences of their decisions, that's when the attorney steps into that role and gains those powers. The final consideration for the scope of an attorney's powers is what property does it actually apply to when we're talking about an enduring power of attorney in relation to property. Critically, it only applies to the personal property of the donor, of that subject person. It does not apply to any trust of which that person is a trustee, even though they may have settled assets into that trust and it may be considered the family trust. A enduring power of attorney in relation to property does not allow an attorney to make decisions as trustee on behalf of someone in their capacity as trustee. The reason for that is that someone's role as trustee is not personal property. So they're not dealing with personal property, and the power itself is not personal property. That trusteeship is not personal property. So then what that means is that anything that is owned in a trust is outside the scope of what an attorney for property is administering. And that can be really critical when someone has structured their affairs so that the majority of their assets are safely in a trust through into their later years, and they've got a comparatively small or minor amount of assets in their personal name to be managed. Classic example would be the family home being in a trust, and therefore if someone loses capacity, the enduring power of attorney in relation to property isn't actually going to be used when it comes to dealing with changing the ownership of the property, selling the property, whatever happens next, putting a tenant in and signing a property management agreement. All of those decisions are going to be made by the trustees of the trust. And when someone loses capacity, then there's an obligation on the trustees to take steps to remove that person as a trustee so that the trust can continue operating. Because most trusts in New Zealand require unanimous approval of decisions. So that means that if someone has lost capacity, they can no longer make decisions, they can no longer give instructions. Now the trust can't make any actions. So although it's not going to be covered under the scope of the enduring power of attorney, your trusted legal advisor should be turning their minds on your behalf to how to deal with that changed circumstance in respect of the trust assets. So today, Simon says that it's important to understand the scope of your powers as an attorney, and if you are setting up enduring powers of attorney, to understand what powers you are willing to give to someone on your behalf. And remember, At LOA Law, we are good lawyers for good people.